Before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, Ron. Good afternoon.
Good afternoon, Your Honors.
My name is Judge Desmond. To my left is Judge Walsh. To my right is Judge Shin. Will be your panel for this one case. Suffice to say, we've read your materials and are familiar with the record, and so you need not go over those things unless they're instrumental to your argument. The docket number is 25P0623, the Department of Children and Families and another versus Mother and another. I understand that mother and child will be splitting their time to 10 and 5, and I presume that mom is going first. And so with that, Attorney O'Brien.
Good morning, Your Honors, or good afternoon. Sorry, it's a change for me. May it please the Court, my name is Tamika O'Brien. I represent the appellant mother in this case. Your Honors, this case asks whether there was clear and convincing evidence that mother was currently unfit on October 1st, 2024, at the time of the trial. The answer is no. The trial judge in this case focused almost entirely on a decision that mother made, and perhaps it was not the best decision. One could, let's just put that out there, in February 2023. But the law requires an assessment of current unfitness at the time of trial.
Sure. So first, let's begin with, if I may, do you challenge any of the judge's findings?
So, Your Honor, we accept the findings as written.
So I'm going to take that as a no. You don't challenge any of those findings.
But we do challenge the legal problem here is that the findings describe past conduct.
I understand.
Sure.
But you don't challenge any of the findings
Correct.
per se. Is that fair to say?
That's fair to say.
Okay.
Okay.
And is it fair to say that mom has, I'm going to ask you, has mom been in compliance with her action plan since she's returned from Nigeria?
It's my understanding that mother's in compliance. I'm not entirely sure if she is currently, like today, in therapy, but she returned August 10th, 2024. DCF left the child in mother's custody. I'm sorry. Left the child in mother's custody during that time. Testified that they had no safety concerns. I would like the court to recognize that this child, in the year that DCF had custody, legal custody of her, she ran from multiple placements.
I get it. Is mom in compliance with her action plan as of today, is my question.
As of today, she's in compliance. As far as I am aware, I have not had DCF.
I'm not sure what that means, as far as that you're aware. I mean, you had to anticipate this question, right?
Sure.
Okay.
But she has provided the child with a safe, stable home. The child is being
At the grandmother's home, or is she in a
at the grandmother's home. She, the child is going to school every day, which in fairness to DCF, that didn't happen when she was in DCF's custody. She had to repeat the 9th grade. So mother's making sure she has transportation to and from school. She is, again.
You say mom's in therapy?
I can't confirm that she's in therapy.
Has she ever been in therapy?
I can't confirm whether or not she has ever been in therapy. I know that that was on DCF's action plan and that she had not returned to the country until August, and that she said once she got stable, she would start therapy.
So prior to her returning from Nigeria, she'd never been in therapy, even though that was on the action plan. Is that fair to say?
I'm not entirely sure that she's never been in therapy. I don't want to.
Record support that she's been in therapy.
I'm sorry, could you repeat that?
Is there any record support that she has been in therapy?
Not that I can recall. So. But in this situation, I think that, yes, therapy would likely help in this situation, but it's not the only determinative factor here.
I understand, but a big part of the department's case, I presume, is going to be the abandonment issue, which really we can't get around. We have to talk about the abandonment issue. And in conjunction with that was, as I understand the record, that mom had taken the 13-year-old with her to the airport to relocate, at least for some period of time, to Nigeria, where mom was, husband is now. I don't know if he was husband quite at that moment then, but husband is there now.
Correct.
And the child indicated to mom, the 13-year-old child, that she wasn't going to Nigeria and was going to leave. And mom reflected on that for a moment, trying to figure out, should I just go to Nigeria or should I take care of my child?
Sure.
And mom elected to go to Nigeria in that moment and left her 13-year-old child, who said, I'll just figure it out, to figure it out. So that decision arguably calls for some therapy. And so I want to know, is she in it?
So, Your Honor, again, I cannot tell you whether or not she is in therapy, but what I can say is that DCF presented no evidence that therapy was necessary to avoid the harm in this situation. Yes, mother made a poor decision in 2023 when she got on the plane. She, let's just face it, shouldn't have done that. She shouldn't have, but in this case.
It's abandonment, right?
Abandonment at the time of trial did not occur. She had returned, she had.
At the time she made that decision, would you agree that was abandonment?
I believe at the time of trial, at the time that she got on the plane, she had not made the appropriate, taken the appropriate actions to care for her daughter. However, she did return.
So it's significant.
It is significant, but it is not the
only. Do I have the timeline right? She returned in August of 2024.
Correct.
She started services in September, and the trial was in October, a month later.
So I'd like to.
Is that correct?
That's correct.
So you think 1 to 2 months of engagement with services rendered her currently fit? Why isn't the mother's remedy to file for review and redetermination, and has anyone done that?
So I'm glad you asked that, and there's a couple questions there, and I want to address both. First, the timeline was very short. Yes, she was back in country a couple months before trial. She was doing well. DCF didn't pull her out of the home. They didn't remove her. There is no reason that DCF could not have said, you know what, things are going pretty well. We're gonna wait. We don't need permanent custody, considering that we don't have another place to put her, and we can wait. And the trial judge did not have to jump to did not have to jump to permanent custody. There were other options. We could have left this in place for now. And as far as the review and redetermination is concerned, and this is something that comes up a lot in these permanent custody cases, and so I've thought about it, and one of the things that I think is really important to notice here is that review and redetermination shifts the burden back to mother. So mother now has to prove that she has a meaningful change.
That's just to go forward, right?
Correct, but then
Okay.
again, it puts
So,
the burden on her.
if the child has been living with the mother for 6 months, 1 year, what have you, and things are going well, that seems to me to be changed circumstances. And then when there's a hearing, the department still has the burden, right? So I guess kind of as a practical matter, I'm not really seeing the harm here.
Okay, and that's fair, but while review and redetermination is available, permanent custody is one of the most significant intrusions of the Commonwealth. And this is important that I want to make clear that under Section 26, the parent loses after permanent custody goes to DCF. They lose all decision-making rights. They lose the right to determine where the child lives. You're basically asking at this point DCF or mother to co-parent with DCF. So the harm is now.
So the short answer is nobody has moved for redetermination. Is that fair to say? Is that the short answer?
I'm the appellate attorney. As far as I know, that has not happened in the trial court.
Okay. And would it be fair to characterize this period of time when mom went to Nigeria, the second period of abandonment? How long had child been with mom prior to going to the airport?
So I believe that child had, I think she had, there was an incident, I think in 2021, but to my knowledge, and forgive me if I have my facts wrong, but I think she was there to 2 years.
Is it fair to say that she'd only been with mom for a few months? Is it fair to say that she'd only been with mom for a few months at the time
Oh,
of
she had
that
been
they got to
reunified.
the airport?
I'm sorry, Your Honor, she'd been reunified, I think, in October or November of the year prior, so that would have been 2022. And then she left in February of 2023.
So a few months. And during that 22 window, how long had she been away from the daughter?
During the 22 window?
Yes.
So from, let's say,
First time she went to Nigeria, well, I'm going to call it the first time. I don't know if it was actually the first time she went to Nigeria. But for purposes of this discussion, the first time she went to Nigeria, how long was she there?
I can't recall exactly how long she was there. But I think that, and my time is running short.
Approximately, I understand.
Sure.
And we have some questions that we want to ask you.
Okay.
So that we can get to the right
Stand here all
decision.
day long, Your Honor.
So, was she there for approximately a year? Over 6 months?
I don't remember exactly the time that she was in Nigeria the first
When
time.
she went the first time, had she made any arrangements to care for her child?
She left their child with her mother.
Had she made any arrangements to care for her child?
She made arrangements for her child to stay with her mother.
She made arrangements to do that?
The child was staying with her mother.
Okay. And had mom
Grandmother.
spoken to DCF before she left?
The second time? No.
First time.
First time. I don't believe that she did.
And she didn't the second time, is that fair to say?
That's fair to say. That's what the evidence shows.
And mom did have some conversation with DCF during those windows,
She did.
but about 2 other children,
That's correct.
and didn't bring up this child.
Unfortunately not.
You have the floor.
I have the floor. Thank you. Your Honor, again, I recognize that this is a tough case for mother. I get it. But at the time of trial, DCF didn't have a better option. Permanent custody was not required to create stability for this child. They did not re-remove her. They had no intention of re-removing her. They didn't have a place for her. Every time they put her somewhere, she ran. The evidence showed that mother's care and custody was the best place for this child as far as the stability goes. She was doing well. She was going to school. She was on track. Yes, mother made mistakes, and there is no denying that here. And I'm not going to insult the court by trying to minimize those. But at the time of trial, a current unfitness was not proven.
And that's for that rather small window that we get to look through.
There were other options available to the trial court.
Relative to the child's 13 years or 15 years at this point of age. And do we know, as you stand here today, that she is indeed living with grandmother?
Yes, and I believe that my sister, who represents the child, can speak more to that. But I can only tell you what mother has told me.
I see that's your time.
Okay, thank you. Are you sure? I'm happy to. Thank you. Thank you, Your Honors.
Thank you. Attorney Diaz, your child?
Yes. Good afternoon, Myrna Diaz, on behalf of the child. May it please the court.
Sure.
This
Do you
microphone's
know if mom's in therapy?
I am not aware of mothers in therapy. I do understand from reading the record that the only thing that mother was not in compliance with, sorry, this microphone is a little unsteady. The only thing that mother was not in compliance with was the therapy part. My client is not in therapy either. She is 16 now. She is enrolled in a GED program. She is still residing with her mother. As a matter of fact, when I speak with her, I have to connect with her through her mother's phone. So she is, sorry, Your
Now,
Honor.
you say she's in a GED program.
Yes.
Was she at the Elliott School for some period of time?
She was at the Elliott School.
What year was that?
I believe that was in 2021.
Was she at the Elliott School when mom returned from Nigeria?
At that time, there was a point in time, I believe, that she was at the Snowden school, and that did not work out for her. So when mother returned in February of 2023, she was residing with mother from November 2022 until February 2023. And that's the point where she ran when she was supposed to go to Nigeria with mother. But she was enrolled at the Snowden school during her 9th grade year, but that did not work out for her due to, I don't want to repeat the record, but there was some conflicts at the school, and she had been getting into some fights there. Sure. And also, mother had disenrolled her, and then DCF had to,
right.
Yes.
So then what school was she enrolled in after that?
After that one, Your Honor, she was at the Snowden school, and then she had been re-enrolled at the Snowden school, if my memory serves me correct. And then at one point, she was at Wayside, and she had been placed there for some time. What my client tells me is that she would prefer to get her GED.
Your client, the child?
Yes, my client, the child, yes, not the mother, the child. She wants to complete the GED program. She wants to become a cosmetologist, and if that does not work out, she would like to become a nail technician. So she has her aspirations, she has her goals in place.
You said she's living with the mother. Is that in the grandmother's home?
Yes. And she's also currently in a youth program, and I apologize, when I transferred my notes over to here, I forgot to put the name of the program, but she is in a youth program that is helping her gain skills in order to find a job that will earn her some money, which is obviously something that teens are interested in. So I'm just, my client's position since the beginning when I was appointed this case is that she wants to reside with her mother. Again, I don't want to repeat anything that my sister just argued, but my client's position, the child's position, is that she wants to remain living with her mother. Obviously, some of the decisions that mother made in 2023 were probably not the best, which may have caused my client to exhibit the behaviors that she was exhibiting at the time and why she continuously ran from foster placements.
Have you, when I read the record, it seemed that at one point while the child was staying with the grandmother prohibited the child from coming back to her home. Is that fair to say?
Yes, there was a lot of behaviors that my client was exhibiting that the grandmother just was not able to handle, and which is why she asked the department for help.
Sure. And at trial, I believe the only evidence that mother and child were going to be staying with the grandmother was mom's testimony. Is that fair to say?
Yes.
Okay. And that seemed to have been met with some question from the court as to whether or not that was truthful testimony, given the relationship with the grandmother and the child in the past. Has anybody seen the child and the mother at the grandmother's house?
I have spoken with my client.
Has anybody seen the child and the mother at the grandmother's house?
I have not seen her there, but I've spoken to my client, and that is where she tells me she is residing, and there is no reason for her to have lied to me, speaking to me outside of earshot of her mother about where she is residing at the time.
And it's your position that mother is now prepared and appropriately responsible to take care of the child?
I don't think I'm the one to make that judgment, Your Honor.
I'm asking, is that your position?
That is my client's position, that she wants to remain living with her mother, and she has her goals in place, and she has not been arrested, or she hasn't ran away, or had any of the issues that she did have when she was in the department's custody.
How long was she in the department's custody?
She was in the department's custody for a little bit over a year, yes. February 2023 until August of 2024, so a little bit over a year.
And prior to that, had she been in the department's custody?
Prior to that, she was residing with her mother.
At any point prior to that, had she been in the department's custody?
She had been added to the department's petition in 2021. So she had been in the department's custody and returned to mother in November of 2022.
And does she have an older sibling who is presently in the department's custody?
It is my understanding from the record is that she's the youngest, so she has 3 older siblings. And I apologize to the court, cannot, off the top of my head, do not know where that child is.
I see that's your time.
Yes, thank you so much.
Thank you. And I'll hear from the department. Attorney Cullen.
Good afternoon, Your Honors. William Cuttle for the Department of Children and Families. Judge Desmond, can you let me know if I'm running over my time? I don't believe I'll need it, but in case I do.
I will indeed.
And we're asking the court to affirm the trial court's decision ordering the child be placed in the permanent custody of the department, finding the child in need of care and protection, and finding mother unfit.
Is it fair to say that mom's doing much better today?
Excuse
Is
me?
it fair to say that mother is doing much better today as far as compliance with her action plan?
I have no evidence about that at all, Your Honor. I mean, and just as you're well aware, that's not before this court. What's before this court is what happened at trial. And what happened at trial is that the court made over 100 findings. Mother testified. I would direct your attention to the trial testimony. To answer your question, mother was not in therapy. She testified she had no intention of going into therapy based on what the department wanted her to do. She's very adamant about that. She testified she'd been in therapy in her past life, but if she was going to do anything, she'd do it on her own. This case, the court in its conclusions of law, I direct your attention to conclusions 8, 9, 11, 13 through 15. That's where the court clearly articulates his findings, his conclusions based on the evidence why mother is unfit. I can go through it, but to just clarify a couple of points. The child was in the department's custody beginning in June and July of 2021. She was having difficulty with her siblings. She was placed with her grandmother. Her mother left to go to Nigeria again. The child had an episode. These are all findings made by the court. Then the mother was gone for 10 to 11 months. I think it was, like a year, approximately 1 year, the first episode from 21 to 2022. The department reached out to the mother to see if mother would come back to take care of the child because the grandmother refused to let her come back to her home. Mother did not come back.
At that time, did we know where the mother was other than Nigeria? Do we know where she was in Nigeria?
No, we've never, well, let me back up to be clear. I think in the record, she testified she was in Lagos, I believe is one place. I'm not sure if it was the first time or the second time. But mother clearly did not cooperate with the department. She didn't let people know where she was specifically. She didn't want to have contact with the department. She came home twice in the 2023-2024 period of time. She was gone for a year and 7 months. She abandoned her daughter for a year and 7 months. And she came back twice on her own, did not tell the department she was there. Then she finally came back in August. So the idea that the court somehow erred by not considering current evidence of mother's fitness is baseless. It's not based on what is the evidence before the court. There was a 1.5-month period of time where the mother came back, and the only evidence that the court found was that she was living with the grandmother, and the court had concluded in conclusion 9 that he wasn't crediting mother's testimony that she could always stay there because, as you had pointed out, Your Honor, the grandmother had asked the child to leave earlier. So that was speculation. Before I go on, do you have any questions for me specifically?
Do you agree that the mom has a bond with the child?
Do I believe the mom? My personal opinion?
Does the record support that mom has a bond with the child?
The court didn't make a finding that the mother had a bond with the child. It looks like the mother had a relationship with the child. Yes. And the argument that because the department wasn't able to provide a safe place for this child, somehow that is equal to somehow the department or the court making a mistake about placing the child in permanent custody.
Well, it sounds like
doesn't
the
make
argument is
sense.
that the child is a handful, and that the child was
The child is a handful.
difficult for mom and was difficult for DCF.
That's right. And what the department has done, and you can look through the court's findings and all the evidence, the department served as a safety net for this child. Clearly, the child was placed in 2 separate foster homes. She grew out of both of them.
One of them had bed bugs, right?
That's true, and that's unfortunate. Yes, yes. But the department's social worker testified he didn't have direct contact with the child. No one seems to have direct contact with this child. But he was aware of her where she was. He would go to court appearances that she had. He was in contact with her siblings, with the father in the case. The department did its best to try to meet her when she needed help. The department offered Mother a service plan. Mother's argument that the department didn't make reasonable efforts is not only not based on the evidence, but it's waived. It wasn't brought up at trial. This is a case that clearly the court had every right, based on the evidence before it, to find that Mother was currently unfit. He did consider, just for the sake of discussion here, he did consider in finding 91 that Mother was taking the child to school in September of 2024, and that they were living in the grandmother's home and had 2 visits. So this is not the kind of case where the court ignored current evidence, just based on all the evidence of Mother not being able to take care of any of her children, abandoning this child twice for over a 2.5-year period of time, not participating in any services, and not having a viable place for the child to live. There was no error. If you have no further questions, I'll rely on the department's brief.
This may be outside the record. I just wondered for my own educational purposes, when permanent custody is awarded to DCF in cases such as this. Now,
Yes?
what does that exactly mean for a child who has a history of running away, for example?
It means that the department still is obligated to provide service to the child if they can, until I believe they turn, I think it's 21, Your Honor. They could provide the same services to the child throughout. And during that period of time, both the child and the mother have a right, if they so choose, to bring a review and redetermination petition before the trial court. I think
Are
you
you aware
asked
if
that question.
are you aware if anyone's done that?
No, I'm not.
Okay. And at a review and redetermination, if whoever asks for it makes a showing of changed circumstances, am I right that at the hearing itself, DCF would have the burden of proof?
Yes, that's on the care and protection of Erin, Your Honor, yes. The mother first has to make a showing that something's changed, and then it's still the department's burden.
Okay, thank you.
It hasn't taken place. So it's this is a difficult case, unfortunately, for this child. She seems to be a survivor, based on what we read in the record, and the department is to support her right now as best it can, and we'd ask the court to affirm the order. Thank you.
Thank you. The matter stands submitted. That concludes our business for the afternoon. Difficult case, sad case. Thank you both. Thank you all.
All rise, please.